Madam Monitor, can we go on the record?
Good morning. Happy Friday. We are on the record.
Thank you very much. We have one matter on today's calendar. Good morning and welcome to the Supreme Court. This is the matter of State versus Bradley. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel for the appellant, please identify yourself and let me know how much time you wish to have for rebuttal.
Good morning, Your Honor. Naomi Fetterman on behalf of the defendant appellant, Mr. William Bradley. I'd like to reserve 10 minutes for rebuttal, please.
Thank you. Senior Associate Justice McDonald will be our timekeeper. Can you see him?
Yes, I can, Your Honor.
Thank you. He will let you know when there's 5 minutes, 3 minutes, 1 minute, and your time is up. Whenever you're ready, counsel.
Thank you, Your Honor. This appeal raises two issues. The first is whether or not Mr. Bradley has standing to proceed with his claim that he was being prosecuted under an unconstitutional statute. And the unconstitutionality is that it violates the Equal Protection Clause because it was based in a racially discriminatory purpose.
Excuse me. I think I missed something.
Oh, I'm sorry, it cut out for a...
Yes.
Yeah.
If you could just repeat, we'd appreciate it so we can have a good record. Thanks.
Cut out on both ends. Wonderful. So as I stated, there's two issues raised on the appeal. The first is whether Mr. Bradley has to pursue the statutory violation at issue. So the first level is that Mr. Bradley, because of his due process entitlement not to be convicted under an unconstitutional statute, has the requisite standing to raise the issue of the statute's unconstitutionality. Now, the basis of the statute's unconstitutionality is its violation of the Equal Protection Clause because it is based in a racially discriminatory purpose.
Justice Doria.
Yeah, I'm sorry. I just want to get this one out of the way early because I think it may go to both issues. I just want to clarify sort of the standard issue. If you're right that your client has standing, but he's not a member of a suspect class or he's not a member of the minority group that's targeted here. Let's say he does have standing to bring this due process claim. Isn't it a rational basis as to your client?
No, respectfully, Your Honor, and I'm so glad you asked this question. I was planning on starting with the statute's unconstitutional.
Counsel, you're cutting out.
She keeps.
We see that replete in the Supreme.
Excuse me, you're freezing up and I'm losing things you're saying.
I'm in very good internet, so unfortunately I'm unsure what else to do. But I can repeat certainly that I was so grateful that Justice Doria asked this question because I do think it is the predicate issue that needs to be addressed, which is that the violation respective to Mr. Bradley is based on the due process clause. But once you address the statute's unconstitutionality, because that goes to a racially discriminatory purpose, we see from the Supreme Court case law that we apply strict scrutiny whenever there is a question of racially discriminatory purpose. So when the constitutionality of the statute is an issue, this court uses strict scrutiny to see if it can withstand muster.
Okay, so let me just make sure that I have that right. And you're going to tell me, I guess, if any of these cases that talk about strict scrutiny, you have strict scrutiny as applied to somebody that is not in a suspect class or a fundamental right is not at issue. I mean, I guess I'm kind of attacking this as a simpleton that it sounds like you're making a facial claim about a statute that may have an unconstitutional purpose. And usually when we do facial claims, you look at whether there is a way to apply it that isn't unconstitutional. And Why wouldn't we look at a rational basis, which is as applied to your client? There is at least, like it or not, a basis for saying public safety or what have you is at issue. You're saying there is case law that says that your client gets somebody gets strict scrutiny, even though they're not a member of the class.
I understand the framework Your Honor is asking about, but the guiding case law is actually the Village of Arlington Heights model with the burden shifting, which is what we fall under as in Hunter v. Underwood, which is also cited in the brief. So once there's a prima facie case made out that race was a motivating factor in the passage of the act, then the burden shifts to the state to show that the act would have been passed without the racially impermissible motive. And this court examines the state's proffered justification with strict scrutiny. So we have a very low burden. We have the burden of the prima facie case to say, look, while we may not be able to say it was the sole reason for the statute's enactment, we know based on the history and the contemporaneous statements that are made that race was a motivating or substantial factor in the passage of the act, such that the act would not have been passed without that discriminatory purpose. And then if this court finds, as we maintain, that we've met that prima facie case, the burden then shifts to the state to say, no, that statute would have been passed without this impermissible motive. And when the court performs that second part of the analysis, they use strict scrutiny.
Okay, thank you.
And that I think the confusion might be that's a little bit separate from the due process violation, which grants our client standing. There's no rational basis or strict scrutiny that goes to addressing the standing due process issue that's specific to our client. But the examination of the constitutionality of the statute involves that burden shifting that we see in Village of Arlington Heights and then is used in Hunter v. Underwood as well. Did that answer Your Honor's question?
Counsel, there's a question from, are you finished, Justice Daria? Justice Khan?
Thank you, Chief. Counsel, my question is this. The appellate court noted that your client, that you did not raise third-party standing. So before we get to the merits of your client's own due process claim, whether the statute as applied to him violates his due process rights, he has to first establish standing. And he first has to have a court say that the statute violates the equal protection rights as it relates to African Americans and Hispanics. But he has to have standing to bring that claim. If he doesn't have direct standing, he can have third-party standing. But you never raised third-party standing, although the appellate court does a third-party standing analysis. My question to you is, I have two questions. One is, you're not claiming a special relationship that gives him third-party standing, are you?
No, I'm not raising third-party standing, Your Honor.
So how is it that your client has direct standing then to bring this claim?
Because he's being prosecuted under the statute, and it's black letter law. I know that the state faults the briefs for the age of the cases, but that's because these are such foundational precepts that no one can be hailed into court on the basis of an unconstitutional law.
Doesn't your client have to first establish that the law violates the equal protection rights and that he has to have this court do that, and in order to do that, he has to have standing?
Yes, but the basis of his standing is the prosecution of Mr. Bradley. So I understand Your Honor's question. If the law is found to be constitutional, then there's been no violation of Mr. Bradley's due process rights.
No, my question is, how does he get to say the law violates the equal protection for African Americans and Hispanics if he himself is not African American or Hispanic? If he had a special relationship, like in the sale of a home and a restrictive covenant, the idea is no one would ever sell to Hispanic or African American. So a white person, a non-Hispanic, non-African American person can raise that claim. that's the third party, but you're not claiming third party. So I'm trying to understand how he gets standing.
He gets standing because he's being prosecuted under an unconstitutional law. And our case law is clear that you have standing to vindicate.
What case law says just because you're prosecuted, you have standing? What case? That's the problem. I don't see a case that says that, counsel.
Well, certainly, and I believe it's Campbell v. Louisiana that says every individual has standing to litigate his own. Oh, page 8 of our principal brief, Campbell v. Louisiana. It is axiomatic that one has standing to litigate his or her own due process rights. And when
right, but you don't get to litigate your own due process rights until there's a finding that the statute violates the equal protection. And for that, you need standing. You're right. Once you overcome the standing hurdle, but that's where I'm struggling. How does he get standing when all the cases say you're either a member of the class or you have this special relationship, this third party standing?
Well, that area of case law would be the aggrievement, which says if you face the threat of prosecution or incarceration, you are classically aggrieved. And we see that in State v. Long, which the trial court applied. Of course, the appellate court disagreed with, but we see the direct specific injury that Mr. Bradley faces is the prosecution, conviction, and incarceration under the statute. And I don't think that there is any ambiguity in that area of law that says if you are facing, and it's beyond actually criminal, it also says civil liability, you are aggrieved and you are suffering a direct specific personal injury that would entitle you to challenge the statute. And the other cases cited in our brief say it comes within the purview if the operation of the statute affects his or her rights. And here we have the operation of the statute, the criminal statute, directly affecting Mr. Bradley's rights because he was prosecuted, convicted, and incarcerated under the statute.
So under your analysis, basically, anytime anyone is prosecuted under any statute, they have the right and the standing to bring an equal protection claim, regardless of whether they've established that standing, just by being charged or by having, if it's a different statute, not a criminal statute, but a civil statute. Somebody can argue, challenge it on equal protection basis, even if they're not a member of that class or if they don't have standing.
I would just, I'm sorry, Your Honor,
I'm just trying to, that's almost akin to saying, well, you don't have to show standing. Maybe I'm misreading it, but I'm trying to understand how the appellate court got it wrong.
Yes, Your Honor, for the same reason the trial court got it right, because the threat of incarceration is sufficient to infer its standing because there is a direct specific injury that Mr. Bradley has suffered. This is not, and when we see the language is the danger is everyone in the community shares a concern about racial discrimination. So we don't let everyone in the community challenge the constitutionality of the statute. But the fact that Mr. Bradley is prosecuted, arrested, and convicted under the statute, that he's being harmed by the statute's operation, that's what gives him standing. That's the injury that he suffered that he's asking this court to redress. As to the second part of your inquiry, it's not as broad, I think, as Your Honor articulated, because you do have standing to challenge any statute that you're being harmed by its inaction, not any statute that doesn't have bearing on you.
So if a member, someone who's not a member of a minority class can challenge under equal protection and say any statute, forget a criminal statute, a civil statute, for their own benefit, even though the statute may not have been enacted for their benefit.
Only insofar as they're being threatened by the statute's operation. That's what you see in these abortion cases, because the doctors face threat of criminal prosecution. The court said not only do they have third-party standing, but they have standing in their own right because they are at risk for incarceration and prosecution.
But they have that special relationship, right? Because by virtue of the fact that they're doctors and they the patients are not going to go to them for the treatment because of the statute. That's different. So in other words, where there's been third-party standing, there's a very close connection, or like in the real estate industry, if it's a restrictive covenant, the idea is that a non-minority person can sue, has standing to sue, because otherwise they would never sell their home to a minority person. There's a causal, connection and a special relationship. I don't see that here. But I noticed that Justice McDonald has his hand up, and I don't want to take up all your time. So I understand your point and where you're coming from, Attorney Fetterman, and I'm going to yield back to the Chief. Thank you.
Oh, thank you, Your Honor.
Justice McDonald.
Thank you, Chief. Let me approach it this way. Rather than using the term standing, how is your client aggrieved?
Yes, and actually that was going to be my response to Justice Khan. He's aggrieved because he's been prosecuted, convicted, and incarcerated, which, well, Justice Khan certainly accurately recounts what courts find with respect to third-party standing. In those cases I just cited, the reason the physicians have standing in their own right and not merely third-party standing because of that relationship is because they're threatened with prosecution. And in the reply brief, the case I think is Diamond v. Charles, that's what we have so unambiguously, is the court saying a physician has standing to challenge an abortion law that poses for him a threat of criminal prosecution.
But let me ask it this way. I mean, I certainly understand that your client is aggrieved because he was convicted under this statute. How is he aggrieved for purposes of raising this claim?
He's aggrieved because everyone has the right to not be convicted under an unconstitutional statute. Again, and that's irrespective of the basis for the unconstitutionality. And that's black letter law we see back from Ex parte Sebald in the 1800s, but reiterated in Montgomery v. Louisiana in 2016. It is a violation of due process to be convicted under an unconstitutional law. An unconstitutional law is as if it is no law at all, and we cannot sustain a conviction under it. And that's just a broad legal principle. And I know it gets a little complicated because the underlying basis is the equal protection violation, but the general principle is unchanged, that it's a violation of due process to be convicted under an unconstitutional statute, whether it's unconstitutional because it violates equal protection or the First Amendment. But every individual who's being prosecuted may only lawfully be prosecuted under constitutional statutes.
Let me ask it this way, and this will be my final question. How is he classically aggrieved?
Because I'm sorry, I know this sounds so redundant, because he was prosecuted, incarcerated, and convicted under the statute. And that loss of liberty is quintessential aggrievement. And we have this court in Gonzales saying even 1 day in jail is a significant infringement on someone's liberty. And so when we have a prosecution, incarceration, and conviction under an unconstitutional statute, that is a concrete injury.
Thank you.
Thank you, Your Honor.
You may continue, counsel, please.
Oh, I'm sorry. I thought Justice Ecker had his.
I didn't see that, counsel. Thank you for pointing that out to me. Justice Ecker.
Thank you, Chief. Just on the same point, I'm wondering, I think I'm probably just making this up because it's not consistent with the Arlington Heights framework, but I'll ask it this way. Is it part of your theory? I understand your point. It's an unconstitutional statute, and I have a right by virtue of being prosecuted under it to challenge the constitutionality. Does your client need to show a causal connection? That is the argument, or the argument could be, I wouldn't be prosecuted on this statute, wouldn't exist, at least in its form that it's in, if it hadn't been for the unconstitutional motive or purpose. I wouldn't be prosecuted because of it. So there's a sort of a causal claim. Does that make sense? In other words, yeah, I mean, that's the source of the injury, is that I'm being harmed because somebody else is racist. And that racism, like most, is overbroad. In other words, it affects not only the people it was directed at, but it affects me because this law wouldn't exist but for that racist purpose. Does that work? Is that supported by any case law, or is that just out of left field?
I don't necessarily think it's out of left field. I don't think it uses the terminology, as you noted, of Arlington Heights, but I think the analysis and the reasoning is correct. If we didn't have this unconstitutional statute, Mr. Bradley would certainly not have been placed in jail and charged criminally and have these convictions, if not for a statute which was motivated by a racially impermissible purpose. So Your Honor describing it as a causal connection, I think, is accurate insofar as it goes to standing for.
I mean, would you need to show that then? Would you need to show that this law wouldn't have been passed if not for the unconstitutional purpose? Is it sort of like a mixed motive situation, or?
Exactly, Your Honor, except the burden is only on us to raise the prima facie case. So we raise the prima facie case that says there was a substantial motivating factor that's impermissible, which is racial animus. Then the burden shifts under Arlington Heights to the state to say, no, we would have passed that statute even without Anslinger's terrible language and racist fear-mongering. This statute would have passed. And then as it relates back to Justice Doria's question, once the state raises that justification, this court uses strict scrutiny to examine whether it actually withstands constitutional muster. So there is the burden, but the burden does not remain on the defendant. It shifts to the state once the prima facie case has been made out, which, again, you see cited in our brief, is a low standard. It's not a burden of proof, it's a burden of persuasion, and we believe we've more than met that in this case. And now it's incumbent on the state to say, these are the legitimate reasons, recognizing the racist history that provides context for this law. These are the legitimate reasons, and this law would have been enacted even absent racially impermissible motives.
Thank you.
Thank you, Your Honor.
Justice Daria.
Let me just ask you a little bit more about the case law. Arlington Heights is not an election access case, but it does have, as I see it, there was an African American who had standing in that case. Correct me if I'm wrong, if I'm misreading that. Any of the other cases that you're relying on, I mean, the Fourth Circuit case you're relying on is, again, an election access case. And the reason I'm asking that question, if you can answer it, if you have other than election cases, is because that is often why we're using strict scrutiny is does the discrete and insular minority, to use Caroline Products language, have access to the democratic process? I'm struggling with understanding how, a non-minority group, I mean, if this was being, our jurisprudence would say they have access to, or maybe this law was perpetuated, notwithstanding a discriminatory purpose. If we stipulate that it was at the beginning, maybe that will be Mr. Rawls' point, is that the state has kept it on the books as applied to everybody. So, can you respond to that at all? Am I clear or just rambling?
No, you are clear, and I'd like to respond to the last part of your question first.
Sure.
Because I think that's the most easily addressed by Hunter v. Underwood, where the state in that case attempted the same argument, saying even if we accept that there were racially impermissible motives, we still think this statute is valid and would have been enacted without that. And the Supreme Court in Hunter, which is cited on page 14 of the reply brief, says, without deciding whether Section 182 would be valid if enacted today without any impermissible motivation, we simply observe that its original enactment was motivated by a desire to discriminate against Blacks on account of race, And the section continues to this day to have that effect. As such, it violates equal protection under Arlington Heights. So I think that's the most direct response to Your Honor's question, is that even if we can make an argument that that's the marijuana prohibition would have been enacted today, we can't divorce that from the original racial animus that caused it to be passed. And there is case law, I don't want, and it's cited in our briefs, talking about that it's the equal protection challenge itself which causes strict scrutiny to be applied, not the race of the party who brings the claim. And if I could have the court's indulgence, I'll attempt to quickly locate it in the brief.
You can do it on rebuttal if you don't want to if you want to use your time
Right.
but that's your call.
Okay, perfect. Page 33 of the principal brief. Importantly, the standard of review is not dependent on the race of those who burdened or benefited by a particular classification. Thus, any person of whatever race has the right to demand that any governmental actor subject to the Constitution justify any racial classification subjecting that person to unequal treatment under the strictest of judicial scrutiny. And that's Gratz v. Bollinger. It's footnote 12 of the principal brief.
Thank you.
And did I address all the parts of your question?
You did. Thanks.
So I think that's where a lot of the appellate court's misapprehension of the claim stems from, is that Mr. Bradley is not asserting his own equal protection rights were violated. He's asserting his due process rights are violated. And that's the mechanism by which he gets standing, because of his due process rights not to be hailed into court under an unconstitutional law. But the second layer, the equal protection argument, goes to the constitutionality of the statute. And so when we accord Mr. Bradley standing, it's because he is very concretely aggrieved by the statute. He is not standing as a member of the community making a general argument against racial discrimination. He is someone who has suffered because of an unconstitutional statute. And if there are no further questions, I will save the remainder of my argument for rebuttal.
Seeing no questions, thank you, counsel. You have your remaining time.
Thank you.
Morning, Your Honors. May it please the court. My name is James Rawls for the Chief State's Attorney's Appellate Bureau for the appellee. I'll try to address both claims, the standing and the merits. Just first, it may in general be black letter law, sort of a truism that you can't be prosecuted under an unconstitutional statute that violates your due process rights. Generally, that's true. But I think the defendant's problem is that they're taking that totally out of context and really in order to do an end run around this standing requirements. Standing requires that you have a personal legal interest involved, not just the general interest of the community, and that you're in fact legally injured, not just arrested, not just charged, not just convicted, but you have a legal injury under this statute. You don't have a right to claim, you don't have a standing to claim the due process rights or the equal protection rights of other people. You don't have that right unless you're a member of that class of people whose rights were injured.
Mr. Rawls, is a question?
I'm sorry.
Just a second.
Thank you, Mr. Rawls. You know, what you're saying certainly rings true, makes perfect sense in traditional, conventional standing analysis. But I can't help but think how directly in conflict it is with all of the rhetoric of the day. You know, I mean, we are writing letters and protesting and standing up and holding signs. I mean, we're not, judges don't, but, you know, all right-thinking Americans, to my view, are talking about how we need to understand that there has to be solidarity between the races in order to overcome racism. It can't just be a black person's problem or a Latino's problem. It has to be our problem. And that we all, it's not metaphorical, we all suffer an injury when any when somebody calls my friend a terrible name, I'm hurt too, and in a real way. And so it seems to me if you apply that here, you know, I mean, one response is, oh, that's nice rhetoric, but, you know, that's not how our law works. But it seems to me that one response to that might be, well, until our law works consistently with our words, then the words are just words and really don't matter. So why shouldn't we recognize a right, at least in this particular context, for, I mean, it's a little weird to say only you know, an African American can challenge a law that was passed. Let's assume it's all true. It's all totally racially motivated. It's just about getting blacks and Latinos. That's what it was about. I don't have anything to say to that. You don't have anything to say about that. This gentleman doesn't have any right to bring that problem to court.
I think legally it would overturn just decades and decades of law on standing. We all, I think, you know, this court said numerous times, you have standing when you have a specific personal legal interest, not just the general interest shared by the community. We all, hopefully, don't want to have laws that are unconstitutional, that are racist, that impact on minorities disproportionately. Absolutely. And we all can petition our legislature to change those laws, and frankly, they probably will change in the next year or less. Marijuana may well be just decriminalized in one way or another.
But we have to wait for an African American defendant.
Well, legally, the injury, the aggrievement, the harm, has to do with whether this statute harmed him.
No, but it's not the application of the law that's discriminatory. That's totally, it applies to everybody. The reason the law is there, the reason the law is there was discriminatory. In other words, the original motivating factor that created the law, that was discriminatory. But now that it exists, you know, it's like a barricade in the middle of a highway. I mean, the person who runs into it doesn't really care about how it got there.
True, but I'd ask this court not to override decades of law and standing. We all have a interest in not having unconstitutional laws, whether they violate equal protection or due process or whatever. But we also have
and this will be my last question. I get your point, and you know, it's a strong one. I don't know how the standing doctrine unfolds. I have to read the cases better, but I get your point. But one response might be that you know, when we're talking about a history of racism, it's that to justify the legal doctrine based on history is exactly the problem. I mean, I'm not saying our standing law created racism in this country, but racism has a history, and maybe to change it, we have to develop some new rules.
Well, possibly. I would ask the court not to change the rules on standing because of that. I mean, it's not as if, I mean, there are times when the law has to step in when third parties really don't have the ability to protect their own rights. Now, defendants said he's not claiming third party standing, but there are certainly times when jurors' rights have been violated and they decide that, well, the defendant can step in and vindicate those rights. But any defendant, minority defendant who's arrested for selling or buying can defend his or her own rights easily in criminal court. So there's no impediment to them raising their rights. And there's no real connection for this man to stand in their place. There are cases that have to do with buyers and sellers and doctors and patients. And even the doctors and the sellers have standing on their own because of the underlying right of their patients to privacy and to have an abortion, or underlying right of their clients to buy alcohol and not be discriminated against because they're males. But there's no underlying right of the sellers here to buy marijuana. There's really just no underlying right involved from those buyers. And absent that, he can't stand in their place and say, well, hey, I'm losing legitimate business. He's not there's no legitimate right to sell or to buy marijuana, period. So he can't stand in their places as a third-party representative or even say that his own rights have been derogated, because they haven't been.
Thank you. Those are good answers, and I appreciate your response.
All right. Thank you.
Thank you. Justice McDonald has a question, sir.
I'm sorry.
Thank you. Well, just to carry on Justice Ecker's line of questioning, let me give you a different scenario. Let's say this was a voting rights case, and the legislature adopted a statute that said that in order to vote, you need to have a driver's license presented, because we know that a disproportionate number of African Americans and Latinos don't own cars and don't drive. And this and a white person is denied the right to vote because he or she does not have a driver's license at the polls. Isn't that person injured in the same way as a member of the minority group if the white person got swept in up into a statute that was derived by racial animus?
I think that would be a little bit different. It's somewhat like that Hunter versus Underwood, Alabama case. People were deprived their right to vote, essentially for moral turpitude crimes. But I think there you've got an underlying constitutional right to vote. You've got a right to be able to go to the polls and not have that infringed on, but you don't have a constitutional right to buy or sell marijuana. It's just different. Well, if you did, that would be one thing. I mean, then you could maybe say, well, I've got this fundamental right to buy or sell marijuana, and you've infringed it. You've put in a law that's facially neutral, but really is aimed at me, and that's impinging my rights. But that just doesn't apply here.
Well, you know, it wasn't when I spent time in the legislature, there used to be two different statutes for minimum mandatories for the possession of powdered cocaine or crack cocaine. And for the crack cocaine, you needed about $30 of crack cocaine. And for powdered cocaine, the exact same chemical, you needed about $2,500. And it was born out of the 1980s when people thought everybody who was on crack was going to break into their homes. And there was a racial component to it. If a white person had been arrested for the crack possession under those statutes that have now been equalized, would he be able to challenge that statute because of the racial undertones that animated the promulgation of the statute?
I think it would be a pretty similar situation to this one.
Well, but it was pretty clear that that's what was going on back then. It was pretty clear that it was targeting a particular community.
Well, just, yes, assuming that the second question is answered, that this legislation was definitely aimed at minorities to persecute them, just like we're assuming that in this case, you still have to have standing. And was this person really discriminated against because of his race, which was the intent, supposedly, of the statute to punish crack users worse than.
It's almost like the argument, I think, is almost not that he was targeted because he's white, but that he got swept up in a statutory scheme that was targeting racial minorities. I mean, it's almost like he's a byproduct of the racial animus, is the argument, I believe.
I understand, and it sounds very similar to the other justices' comments. I think that would still derogate this law on standing, where you're not aggrieved because you were arrested and convicted. You're aggrieved because of this supposed unconstitutional intent and effect. The legislature supposedly intended to discriminate against minorities, and it did so, even though it was facially neutral. So I think the law on standing would still apply there. And I haven't seen any case anywhere which talks about this, quote, black letter law, about not being prosecuted under something that's unconstitutional, applied in this kind of context. Each and every one of the cases that are raised, Bond defendants claimed in various cases that Congress didn't have the power to haul them into court because they couldn't regulate chemicals. Congress couldn't give them life without parole because that's unconstitutional. Congress couldn't regulate the elections, and other cases that had to do with double jeopardy, et cetera, et cetera. All those had to do with that particular litigant's personal rights. None of them had to do with that litigant's contention that other people's rights were being violated, that minority rights, not him, but minority rights were being unconstitutionally violated. Not one of those cases dealt with this type of situation. So to reach the defendant's view is just to essentially eviscerate the law on standing.
Thank you, counsel.
Okay. I think,
Mr. Rawls,
I'm sorry.
what I find odd about this is race is tremendously complex. Whether it's biological or a social construct, I tend to believe it's a social construct more than any biology whatsoever. So if this gentleman, and it's not the case here, but if this gentleman had said, I did my DNA test and it turns out that I'm 2% African American, I'm 2% Black, and so therefore I self-identify as Black, he would have standing, wouldn't he?
That's good. I think that's a good point. He could say that. It's interesting.
I suppose Rachel Dolezal, who impersonated a Black person for years, could say, I self-identify, and she has said that, I self-identify as Black, because race isn't what you thought it was, it's something different.
Yeah.
I suppose he would have standing, but in this case.
Well, I don't know, but I think part and parcel of their claim is, well, the legislature made this facially neutral law, but we all know that they were trying to get minorities. And how would minorities be targeted? Well, because they use this more often. So I guess the basis of their assumption, supposedly their assumption by the legislature in the 1930s was that minorities use pot a lot more. And therefore, if we even apply this, state this neutrally and apply it neutrally, we'll still get a lot of minorities arrested and charged and convicted. So I guess it's interesting, but
I'm just saying as to the standing issue. If
right.
He said, I identify as Black, right, he would have standing, I think. But that's not the case here. And
correct.
So saying traditional notions of standing wouldn't permit this case to go forward. It's interesting.
Yes, good point. I'm not sure if I have a better answer than that. I guess just harking back a little bit to some of the other justices' concerns, court is, not sure if it's this court or the federal courts, but we generally agree with the federal law on standing. We use some different language, but we pretty much agree. You don't have standing to claim laws unconstitutional as applied to third parties, and courts aren't roving commissions rendered to pass judgment on the validity of laws in general. They're just not. I mean, there may be plenty of laws that are unconstitutional in one way or another, and they shouldn't be on the books, and there should be something done about it. I agree, but it's just for standing, we still need to have parties that have a legal interest, not just being arrested and convicted, but a legal harm. And if that harm is not there, if it's harm to others but not this defendant, then this court shouldn't step in and change the law of standing that's been around for decades. It has a good basis. I'll try to briefly, if I can, I guess, get to the second issue, really just the merits. I think it's pretty clear that even looking at the sparse evidence that defendant raises, there's no evidence that the legislature in the 1930s knew that this Mr. Anslinger was supposedly racist. There was comments referring to him, but nothing about the fact that he was racist, and that's why this law was being passed in all the states uniformly. There's no comments to indicate that at all. And of course, the law was neutral on its face. And there's certainly no evidence that the legislature intended to do this purposely, to discriminate against minorities in this fashion. So no evidence that they're aware of, much less intended to discriminate. But there is, in fact, evidence that they wanted to have uniform laws with other states, and they thought, rightly or wrongly, they seemed to think that there was a health issue too, a safety issue. Maybe that's not true at all today. Maybe we know differently. But that seems to be what the evidence shows that legislature was acting upon. Uniformity, the benefits of uniform laws, and protection of public health. So I think that's clear that there's no problem with the intent of the statute. And of course, if there were some problem for those same reasons, I think the state could easily overcome that burden shifting and show that it was not passed because of racial animus, but in spite of it. They wanted to protect people's health. They wanted to have uniform laws. This law would have gone into effect anyways. We already had laws on opiates and cocaine, and we just added one more, marijuana, in the 1930s. So I think on the merits, there's just no problem whatsoever. I'm not sure that I have much more to add unless I haven't answered some of the questions that the court might have. I think.
Counsel saying none. Thank you very much.
Thank you very much.
Attorney Fetterman.
Thank you, Your Honor. And I'd like to begin by confronting this idea that somehow we're making this novel standing argument. And I think maybe the best way to counter that is to look at the language the state cites in its brief on page 8 about what is required for standing and to challenge the constitutionality of the statute.
Counsel, before you do that, for some reason, Paul's graph is stuck in my head, which has nothing to do with this case. But it's almost, I seem to be hearing, but for the unconstitutionality of this statute, I would not have been prosecuted.
I would agree with that characterization, but for the enactment of a statute prohibiting cannabis, I could not be charged and incarcerated and convicted by the state. And that's precisely the analysis. And that's ironically or notably what gives him standing.
And so is it your position that the standing is just to get him through the door? As far as the argument on the unconstitutionality, you'd like to have that argument, and you may even lose that argument.
Well, sadly, I might lose both my arguments, but if I could, and I don't want to, I seem to be having a little difficulty conveying, so if I could rely on this language that the state cites from Gill v. Schimmelman, which is under Connecticut standards, only members of a class whose constitutional rights are endangered by a statute may ask to have it declared unconstitutional. So I'm not sure there is a way that the state is legitimately arguing that Mr. Bradley's constitutional rights have not been endangered. Specifically, his liberty has not been endangered by the statute.
No, I think I and the folks on the panel actually do understand it. It's just this comes up in a totally non-traditional way.
I would agree with that.
And so I think that's the difficulty we're having with it, and we're just probing to try to figure it all out. I think that's what's happening here.
And I can certainly appreciate that. And I guess where I'm struggling to articulate it to the court is, even though it is not his equal protection violation, he certainly has a constitutional right, a due process right, his liberty interest, not to be imperiled. And our case law understanding says that that is enough. If you're being hurt by the statute, you may challenge the statute's constitutionality. It doesn't say you may only challenge the same constitutionality that causes the violation, right? This is not discriminatory enforcement like we see in McCleskey that says you have to be a member of the class. If you're saying discriminatory enforcement, then you do need to be a member of the class. The law on standing in its broadest, most general sense is if you're hurt by the statute, you can challenge the statute. And we see that in State v. Long, and even though the appellate court disagreed with the trial court's analysis of Long, we have the appellate court citing to Ramos, which still has the same underlying principle, which is the threat of prosecution is enough for standing. And our response to that, of course, is we don't have the threat of prosecution. We actually have prosecution. So how is he not aggrieved? If you're saying that in Ramos, the minor and his mother faced the threat of prosecution, so they're aggrieved. In Long, he faced the potential of further commitment. He's aggrieved. Mr. Bradley similarly is aggrieved. He is being prosecuted under the statute.
There's a question from Justice Ecker.
Thank you, Chief. The question earlier that my colleague Justice McDonald asked of Mr. Rawls, I just wanted to ask you about the crack cocaine. Sounds like a pretty good analogy, you know, and I know that there was a lot of federal litigation over that before the Sentencing Commission changed the guidelines, I think, but a lot of cases. Do you know if any of those cases were brought by non-African Americans or people like your client, I guess, and whether there was any standing issues ever resolved in any of those cases?
I don't. Certainly Justice McDonald's comparison is an apt one. I had looked at those cases, but it seemed like before there was any sort of adjudication, there was just mass resentencing of defendants under the adjusted guidelines. So I can't point this court to any specific case law that addressed the standing issue in that context.
I can look for it. I was just wondering if you knew any cases. Thank you.
Thank you, Your Honor.
No, go ahead, counsel, please.
Oh, no, I was just going to add that I think that is a good analogy for the situation here. We have something we know, a statute we know based in racial animus, but then applied indiscriminately to whoever was arrested with crack was certainly subject to the crack guidelines as opposed to cocaine, irrespective of race.
Thank you. Justice Khan.
Thank you, Chief. You have your hand up, Chief. I don't want to, you have more seniority. Do you want to go?
I was after you.
Okay.
And I'll pull a rank if I want to.
Okay, all right. Attorney Fetterman, your argument about the statute is undoubtedly compelling. So let's assume, it certainly disproportionately violates the equal protection rights of African Americans and Hispanics. Let's assume there's no dispute about that. When it comes to standing, isn't the issue really, how are your clients' equal protection rights endangered? And that's, I think, what the purpose of the standing is, that whoever can bring the equal protection claim has to show that their own equal protection rights are endangered. And that's why there's that, in the real estate industry, and there's that causal connection. So that's, I think, what we're struggling with. I understand generally being prosecuted, you're aggrieved. But when the claim is one based on equal protection, with the exception of the Chief's questions, which is if someone identifies with a particular class because they're in fact a part of that class, that's a different situation. Then they fall into that category. Or by virtue of some other relationship, they can fall into that category. But how does your client, in this case, show that his own equal protection rights were endangered?
Well, and I think that's the fundamental disagreement that we have with the state, which is that he doesn't need to show his equal protection rights are endangered. And that's, again, why I quoted from the state's brief. So you can see that the language is members of a class whose constitutional rights are endangered by a statute may ask to have it declared unconstitutional. So his due process rights are endangered. His liberty interest is endangered by the statute. So he can ask to have it declared unconstitutional. unconstitutional being because it violates equal protection, because it would maybe violate the First Amendment, whatever the basis for the unconstitutionality.
So then you agree with your opponent that your argument is basically saying, let's eviscerate standing, as far as for purposes of standing, you just need to have some generalized injury, not a concrete particularized injury that underlies the equal protection claim.
No, I would absolutely disagree with that characterization. And again, I would point to State v. Long and Ramos, which the appellate court relied on, which hold that a genuine likelihood of criminal liability is sufficient to confer standing, because that is the concrete, particularized, specific legal injury.
But in one of those cases, the individual had mental illness, and the court found that he was actually a member of that class. In the Chief Justice's example, someone who, may not look like they are Hispanic or Black, but may have, in fact, a percentage of their DNA or whatever that, race is, may identify as that, is different. But the chief has questions, and he certainly has a high ranking, and I think you answered your point. I'm going to yield back to the chief, and I thank you, Attorney Fetterman.
Thank you, Your Honor.
Counsel, I just quickly thought about the racial disparity case involving people on death row. Did you look at that case?
I think McCluskey v. Kemp, I'm familiar with it. I can't profess to, have very fast recall at this point.
And we didn't get to rule on that case because the death penalty was abolished in Connecticut. But I was just wondering if you had an opportunity to look at that, and did you find it either helpful or not helpful?
If I see my time is up, if I may respond. I think the difficulty or the danger in using those sorts of cases in this context is because those discriminatory enforcement cases do require that the person be a member of the class that is being actively discriminated against by a validly enacted statute having a discriminatory effect. I think the case law is clear. You do need to be a member, but that's not the situation here when we're dealing with a constitutional violation because of the discriminatory intent in enacting the statute. So it's not a valid statute that's being applied in a discriminatory manner. It's an invalid statute that's being applied. And no matter how fairly it may be applied, it's still an invalid statute. So that's, I think, the important distinction when looking at that line of cases.
Thank you very much. I believe your time is up. If you have an ending statement, you may make it.
No, just simply to say, as always, thank you so much for your attention and your consideration of this matter.
Okay. I want to thank counsel for being very well prepared. This is sort of an unusual case, and it's hard to wrap our arms around. And oral argument was very, very valuable in this particular case. Counsel often asks me, is oral argument worth it? And I have to tell you, when it is, it really is. So thank you so much, and I appreciate it. With that, we are in recess until Monday, adjourned until Monday. Thank you very much. Everybody have a nice and safe weekend. Take care.
Thank you.